video, we're going to be talking about litigation and other forms of advocacy. This section of the rules makes up 10 to 16% of your total MPRE examination. The first rule that I would like to direct your attention to is candor to the tribunal. This rule has multiple parts. We're going to pull it apart piece by piece and talk about some examples. The rule says that a lawyer shall not knowingly make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So let's stop there. This is pretty loaded, but what this says at its most basic level is that you should not lie about the facts of your case or about the law as it relates to your case. Further, if you find that you have made misrepresentations about the facts of your case or about the law, you need to take steps to correct it. The example in the outline says a lawyer cannot argue that a case is controlling when she knows that the highest tribunal in the state has reversed it. The second example says, on a traffic ticket case, the judge says, since this is your client's first speeding ticket in over 10 years, we'll drop the ticket. If the lawyer knows that this statement is false, the lawyer would not have to correct the judge unless the lawyer or his client caused the mistake. Thus, the key is the lawyer as the advocate cannot be the one that's making misrepresentations about the facts or the law. And if the lawyer finds out that they have, maybe their client lied to them and they made a representation to the court and then later came to find out that it was in fact not true, then they need to correct that representation. The second part of the rule states, a lawyer shall not knowingly fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. First things first, this rule requires lawyers to do opposing counsel's job when opposing counsel is not doing it. Keep that in mind. The other thing to keep in mind here is that the rule uses the phrase controlling jurisdiction. Thus, you must pay special attention to those jurisdictional facts that are provided to you in your fact patterns, because those could be there for a reason as it relates to this rule. Turning to the example on this point found in your outline, it says a lawyer is arguing a motion in a lower court in State A. There are two cases on point with very similar facts. However, not favorable to the lawyer. One is from a lower court in State A, and the other is from the highest court in State A. There is also a case on point in State B. The lawyer has to disclose both of the cases from State A because they're from her controlling jurisdiction. The lawyer does not have to disclose the case from State B because it's not from her controlling jurisdiction. Therefore, those are the types of jurisdictional facts that I would be on the lookout for in your questions. The next part of the rule states, a lawyer shall not knowingly offer evidence that they know to be false. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence, and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including disclosure to the tribunal. So I'm going to stop there. This is, again, a very loaded rule. The rule first pertains to lawyers and the words they speak, but it also extends to those people the lawyer puts on the stand. Thus, if a lawyer puts a witness on the stand and they know the witness is lying, the lawyer then has an obligation to take reasonable remedial measures. So what is the lawyer supposed to do in this situation? Well, the first step is that the lawyer should talk to their client in confidence. The lawyer should advise the client that they have ethical obligations under these rules and that they, the lawyer, cannot offer false evidence. The lawyer should seek their client's cooperation with respect to withdrawing from the action, assuming that withdrawal would fix the problem, or correct the false statement or the false evidence. Ideally, the client complies. But if that fails, the lawyer's obligation does not end there. The lawyer should take steps to remedy the representation of false evidence. So, if withdrawal from the representation is not allowed, or if it does not undo the effect of the false evidence, then the lawyer must make disclosure of this false evidence to the tribunal as it is reasonably necessary to remedy this situation. even if doing so requires the lawyer to reveal information that is otherwise protected by the duty of confidentiality. Then, once the lawyer does this, it's in the court's hand to decide what they're going to do next. This duty of candor continues to the end of the proceedings. This means there's a final judgment that has been affirmed on appeal, or the time for appeal has expired. The other thing I want to point out that I haven't mentioned yet is that this rule uses the word knows. That means there is a knowledge requirement. So if there is a situation where the lawyer merely suspects that someone is lying or merely thinks that someone might be offering false evidence, that doesn't trigger this rule. Now, a lawyer can't, turn a cheek and claim they don't know something when they do. But if a lawyer just merely suspects that someone is testifying falsely or might testify falsely, then it does not trigger this rule. For example, a man is being represented by a lawyer in a personal injury action. The lawyer gets to know his client a little bit as trial is approaching. The lawyer gets this bad feeling that the client might lie on the stand. Does this rule preclude the lawyer from putting that client on the stand? And the answer is no, because the lawyer does not know that the client is going to testify falsely. I want to give you another example. Let's say a man hires a lawyer to represent him in an action against the government because the man is alleging that his land was taken by virtue of a regulation that was passed, and he's entitled to just compensation for that regulatory taking. The lawyer puts the man on the stand, and the man testifies that he paid $100,000 for the land in question. Later, the lawyer finds out this was a lie. The man only paid $50,000 for the land. So the lawyer tells the man, "You have to correct this false statement." And the client refuses. In this situation, the lawyer would have to take the next step and reveal to the court the fact that the man lied and the land was only $50,000 and not $100,000 in cost. The court would then decide what to do from there. Turn to the next portion of this rule. It's all about what to do if you know your client will testify falsely. Remember, we just talked about a situation where a lawyer put someone on the stand and they lied. This next portion of the rule is discussing what to do if the lawyer has not yet offered the evidence, but knows that the evidence in question is false. Therefore, the rule speaks to two different moments in time. So turning to this specific instance, when the lawyer has not yet offered the evidence, but knows a person wants to testify falsely, what are they to do? Well, the answer to this question depends on the type of case it is. Let's first talk about how to handle this in regards to a civil case. In a civil case, if a lawyer knows that their client intends to testify falsely, or if they want the lawyer to introduce false evidence, the lawyer should first try to persuade the client that they shouldn't testify falsely or that the evidence in question should not be offered. If this persuasion is ineffective and the lawyer still decides that they want to continue to represent the client, then the lawyer should just refuse to offer the testimony or refuse to offer the false evidence in question. Therefore, please note, there is no right for a civil client to testify. It might really make your client mad if their lawyer refuses to offer their testimony, but they do not have a constitutional right to take the stand. Now, if only a portion of the client's testimony is false, or if the client just wants to testify falsely as it relates to a certain aspect, then the lawyer can put the client on the stand and not ask about those types of issues, or not get into that area in which the client intends to falsify their testimony. But generally speaking, no, the lawyer has the right to not offer the evidence in a civil case. In a criminal case, the approach is different. This is because the client is a criminal defendant and does have constitutional protections about their ability to defend themselves and to testify on their own behalf. So if a lawyer is dealing with a criminal defendant client and they want to testify falsely, what does a lawyer do in this situation? Well, the first step is similar to the first step we previously outlined. The lawyer should try to level with the client and try to persuade them not to lie. The lawyer should explain to the client that they cannot offer false evidence and what will happen if false evidence is offered. Further, the rule requires that the lawyer should consider withdrawal if that will solve the problem. But usually, it doesn't. The third and final step is for the lawyer to reveal the situation to the judge and let the judge decide what to do. Thus, The key difference between a civil and criminal case is that a criminal defendant or client has a right to testify, where a civil client doesn't. The final rule in this section that I would like to cover is all the way towards the end of this section, and it's about lawyers acting as a witness. Let's talk about the general rule first. The rule states that lawyers should generally not act as a witness, absent an exception. A lawyer shall not act as an advocate in trial in which they're likely to be a necessary witness. So, stopping there, I think this rule makes some common sense. It would be very strange and awkward if you had a lawyer who is questioning witnesses and cross examining witnesses and introducing evidence to the jury. And then he or she goes and gets in the witness box themselves. We don't want someone acting as an advocate in trial and then later testifying as well. Therefore, the general rule is they shall not do that. Now, let's turn to the exceptions. The first exception says that you can be an advocate at trial and a witness if you're going to be testifying to an uncontested issue. The second exception is if the testimony relates to the nature and the value of your legal services that have been rendered in that case. The third exception is if disqualification of the lawyer would pose substantial hardship upon the client. So if you don't have one of these exceptions that are applicable, the general rule is a lawyer shall not be the advocate for someone in a case and simultaneously be a witness. The other thing I want to stress is the word necessary. Sometimes you'll get questions that are really testing the plain language of this rule. If the lawyer is very clearly a necessary witness in the case, then they should not be a lawyer in that case. That's because if they're needed to be a key witness, or as the rule states, a necessary witness, then they should simply be the witness and not the lawyer, because you cannot do both here. Now, the next part of this rule says that a lawyer can act as an advocate in a trial in which another lawyer in their law firm is likely to be called as a witness, unless precluded from doing so by the conflict of interest rules. This is a situation where a lawyer works at, say, a big firm, and one of their associates is representing a client. Another lawyer in that firm can then act as a witness in that case, even though someone else from their firm is representing the client. This is fine as long as this does not amount to a conflict of interest. So that wraps up this section of the rules.